unable to join because of the notice. I spoke to a couple of them who said they were out of town and would not be able to rope for the Zoom proceedings. So I'm sure we can go on. Maybe their inability to join is because they ordinarily wouldn't even join.
Well, anyway, all the notices have been sent. All the notices have been sent, and I will take appearances. Appearance.
Very well, my lord. With due respect to the court, Ahmed Badamasi is my name. I appear for the claimant.
Any appearance of the defendants? None. Judgment. In reading the judgment, I shall simply read the introduction and claims, and then I will go to the judgment section, the decision section portion. The claimant filed this complaint against the defendants on the 20th of February 2015, together with the accompanying originating processes. By an amended originating process filed on 4th December 2017, the claimant is seeking the following reliefs. A declaration that the claimant, a registered trade union, is the only body stroke union legally recognized under the Trade Unions Amendment Act and legally empowered by law to unionize tippers, truck owners, and employees within the quarry industry stroke sector. B, a declaration that the various acts of the defendants amounts to usurpation of the functions and powers of the claimant. C, an order restraining the defendants from carrying out the functions and duties of the claimant, a registered trade union in any capacities whatsoever. D, an order directing the defendants to remit the toll fees, stickers, charges, and other payments illegally obtained from members of the union from 23rd day of April 2013 till date, in whatsoever guise forthwith. The first and fourth defendants filed a joint statement of defense on 14th March 2016, together with the accompanying processes. The second defendant statement of defense is filed on 26th of March 2015. The third defendant did not defend the action. I will go straight to the decision portion. I have carefully considered the processes filed, the evidence led, written submissions, arguments, and authorities cited. I begin with the fundamental issue of jurisdiction raised again by the defendants. The first and fourth defendants had, by a notice of preliminary objection filed on 8th July 2016, challenged the jurisdiction of the court to entertain this complaint. In a considered ruling delivered on 4th June 2018, the objection was dismissed and the court assumed jurisdiction. The defendants elected not to file an appeal against the ruling. By raising this issue again in final address, both counsel to the defendants are asking this court to sit on appeal over its own decision, revisit it and review it, and then set it aside. This court is functus officio and cannot assume an appellate status over its decision. See CTEC International Estate Limited versus Francis and others. Also see Augustine Ene versus Chief Asuko Asiko. The ruling remains the correct position and stands until set aside by the Court of Appeal. Learned counsel to the first and fourth defendants submitted that this court is bound to enforce or give judgment to the decision. This court is bound to enforce or give effect to the judgment of Savage J in suit number IKD/M/24/14, as orders of courts must be obeyed, even if perverse, until set aside by the courts that made it or on appeal. He relied on the provisions of Section 2873 of the 1999 Constitution as amended. I reproduce the provision as follows. The decisions of the Federal High Court, the National Industrial Court, a High Court, and of all other courts established by this Constitution shall be enforced in any part of the Federation by all authorities and persons, and by other courts of law with subordinate jurisdiction to that of the Federal High Court, the National Industrial Court, a High Court, and those other courts respectively. The judgment in suit number IKD/M/2414 is a judgment of the High Court of Lagos, a court of coordinate jurisdiction with the National Industrial Court. This court is not bound by the judgment of the High Court of Lagos and is not bound to enforce it or give effect to it. The intent of the submission by counsel is that the National Industrial Court is not a court of record. This is most unbecoming and disrespectful to this court. It also shows a lack of understanding of the meaning and purport of Section 2873 of the 1999 Constitution. It is the law that a claim is circumscribed by the reliefs claimed, and the duty of a claimant is therefore to plead only such facts and materials that are necessary to sustain the reliefs and adduce evidence to prove same. See Gabriela TVA versus Cable Metal. The claimant has asserted in its pleadings and evidence that it is a registered trade union under the Trade Union Act. The defendants do not dispute that the claimant is a registered trade union. I take judicial notice of the fact that this court has in Mr. Ndidi Okwagbo, for himself and on behalf of the Union of Tipper and Quarry Employers of Nigeria versus the National Union of Road Transport Workers, suit number NICN/AWK/25/28 on reported judgments delivered on 24th February 2020 declared that the claimant is a body duly registered under the Trade Unions Act. There is no dispute between the parties that the defendants are associations registered under Part C of the Companies and Allied Matters Act. The first defendant's certificate of incorporation and its constitution, exhibits D1 and TA1, are in evidence. Likewise, the constitution of the fourth defendant, exhibit TA2. The claimant's complaint is that the defendants who are not registered as trade unions have usurped its functions by operating as a trade union within the quarry industry. The issues that arise for determination are therefore as follows. 1, what is the jurisdictional scope of the claimant's trade union? 2, whether the right to join a trade union is absolute. 3, whether the claimant is entitled to the reliefs it is seeking. Upon a request made by the claimant to the Federal Ministry of Labor for its jurisdictional scope, the Federal Ministry of Labor, by its letter to the claimant dated 11th March 2014, Exhibit C7A, stated the claimant's jurisdictional scope as follows, and I quote, that the jurisdictional scope of Union of Tipper and Quarry Employers of Nigeria covers the unionization of tipper/truck owners and employers in the quarry industry, and also the drivers who are owners of the truck/tippers they are driving. I must state that the source of jurisdictional scope of trade unions in Nigeria is statutory. It is derived from the third schedule, parts A, B, and C as contained in the Trade Unions Act, Cap T 14 LFN 2004 as amended. Jurisdictional scope is therefore statutorily regulated, compartmentalized, and well-defined. It defines the limits within which such jurisdiction is to be exercised by a trade union. See Osawe versus the Registrar of Trade Unions. It streamlines the trade unions, industry, and prevents a chaotic labor regime. It is helpful at this juncture to reproduce the following sections of the Trade Union Act. And I quote, Section 3.2. No combination of workers or employers shall be registered as a trade union, save with the approval of the minister of his being satisfied that it is expedient to register the union either by regrouping existing trade unions, registering a new trade union, or otherwise, howsoever, but no trade union shall be registered to represent workers or employers in a place where there already exists a trade union. Section 5.4. The registrar shall not register the trade union if it appears to him that any existing trade union is sufficiently representative of the interests of the class of persons whose interests the union is intended to represent. Section 5.7. Notwithstanding anything to the contrary contained in this act, the registrar shall, on the coming into effect of this section of this act, register the trade union specified in Part A and Part C of the third schedule to this act. And on such registration, the said trade union shall have all the powers and duties of a trade union registered under this act. The Registrar of Trade Union found it expedient to register the claimant as a new trade union, and it is clear from Exhibit C7A that the claimant's area of jurisdiction as a trade union has been clearly defined and is limited to the quarry industry. The constitution of the fourth defendant, Exhibit TA2, has as one of its aims, and I quote, to enlist, recruit, and register as members, operators of tippers and lorries by road in Ikorodu local government area in Lagos, end of quote. This particular aim strays into the jurisdictional scope of the claimant and could be a source of conflict in this industry. I hold that the claimant is the trade union legally recognized under the Trade Unions Amendment Act and legally empowered by law to unionize tippers, truck owners, and employers in the quarry industry sector, and also the drivers who are owners of the tippers they are driving. The defendants have asserted that they have a right to belong to any union or association of their choice. On this issue of voluntarism, the right of a worker, employer to decide which union to belong to is not absolute, but must be exercised within the limits of the Trade Union Act. Voluntarism and the freedom to choose which union to belong to is limited to the trade unions empowered to operate within a clearly defined jurisdictional scope. Voluntarism must exist within and not outside all existing relevant laws and regulations. See NCSU versus ASCN, see also Osawe versus the Registrar of Trade Unions Supra. Even the fundamental rights guaranteed in Chapter 4 of the 1999 Constitution as amended are not absolute. Sections 45(1)A and B provides for derogation from these rights. The right to choose which union to belong to is a qualified right, and I so hold. The claimant has complained that the actions of the defendants in issuance of tickets, stickers, collection of dues amounts to usurpation of its functions, powers, and duties. It is the law that once a party asserts, he must prove the assertion. Section 1311 and 2 of the Evidence Act. The question is, what are these functions, powers, and duties? Section 4.1 of the Trade Union Act provides, and I quote, every trade union shall have registered rules which shall contain provisions with respect to the various matters mentioned in the first schedule of this act. Some of the matters mentioned in the first schedule to be provided for in the rules of a trade union include, and I quote, the whole of the purposes of the trade union and the purposes for which its funds may be applied, the subscriptions and dues, if any, which members are required to pay. If the trade union is to provide benefits for its members, the qualifications for membership of the trade union, which shall include a provision to the effect that such a person shall be normally engaged in the trade or industry or elected or appointed to represent workers' interests in the said trade or industry. The claimant fails to produce in evidence its registered rules that would enable the court to ascertain all of its functions and duties and make a determination on whether the defendants have usurped and or prevented the claimant from performing all its functions and duties which are solely reserved for it in its registered rules. Consequently, claim B, C, and D must fail. They are refused. On the whole, the claimant's case partially succeeds. I hereby declare that the claimant is the trade union legally recognized under the Trade Unions Amendment Act and legally empowered by law to unionize tippers, truck owners, and employers in the quarry industry, sector, and also the drivers who are owners of the truck, tippers they are driving. Each party is to bear its own costs of this suit. Judgment is entered accordingly.
As the court pleases, my lord, we are very grateful for this well-considered judgment, and on behalf of the claimant, we appreciate the court and also wish the lordship a beautiful Christmas holiday. We're grateful, my lord. Yes, my lord.
Court to rise.